If you've been watching or reading the left-leaning media over the past few days, you would probably think Donald Trump is absolutely, definitely getting indicted after the Mar-a-Lago search warrant and the redacted affidavit were released. And over on the right-leaning channels, they're almost entirely focused on trying to undermine and attack the FBI. Now, here we play it straight. First, let me tell you that I don't have all the answers. No one not directly involved in the investigation does, no matter what they tell you. But based on what we do know, I'm not yet convinced that Trump is going to get indicted. There's a lot that goes into that decision, and there is a lot more we don't know, particularly on the question of allegedly obstructing the investigation and the government's effort to get the documents. That portion was almost all redacted in the affidavit. But as of right now, for reasons I'll explain in a moment, I'd say there's maybe a 40% chance of an indictment. That's a real chance. But watching CNN and MSNBC the past few days, you would think the cuffs are coming any day now, and this is just a slam dunk.
In my view, that is enough. That is sufficient to bring an indictment, and certainly enough to get a conviction.
Former president is going to be prosecuted. I don't see how you cannot, given this information.
I will be discussing and debating with one of those legal analysts in a moment, but one of the things that appears to be ignored is that these 184 classified documents we've been hearing about for the last week, some of them the highest level of classification, were found in June. It's not like the DOJ just got them. They've had them for months. They've had ample time to indict Trump. If the possession of the documents themselves is the crime, then they could have indicted and avoided the claim about it being too close to the midterms. They didn't. Maybe the main purpose of the search was that the government just wanted all this sensitive stuff back in a secure location. I don't know. But more people need to say, I don't know. For starters, why was Donald Trump keeping these documents? Was it because they were personal mementos, or did he have some other possibly sinister reason for holding them? The president was going to look to impress his golf buddies with some letters from his presidency. Even if they were highly classified, it's hard to fathom the DOJ would move forward with a prosecution for keeping those documents, even if he absolutely should not have kept them. If, on the other hand, he had a more ominous reason for withholding them, it's a totally different story. But we don't yet have the evidence, for example, that Trump's motivations were nefarious, and what exactly the documents were matters here. Yes, technically, for the 3 statutes that are being investigated, the documents don't even need to be classified to be a violation of the law. But as a practical matter, of course it matters. There's a difference between truly jeopardizing United States sensitive information, methods, and sources, and a personal note from Kim Jong-un. And there should be. And then there's maybe the single most important question of what did he do to supposedly prevent the FBI from getting access to these documents? How bad or egregious was the conduct? What is on the Mar-a-Lago surveillance video that the FBI has? Unfortunately, we didn't get any insight on that from the affidavit. That part was all redacted. Now, this passage of the affidavit is critical, and I'm going to read it. The FBI's investigation established the documents bearing classification markings, which appear to contain national defense information, were among the materials in the 15 boxes and were stored at Mar-a-Lago in an unauthorized location. Further, there's probable cause to believe that additional documents that contain classified national defense information or that of presidential records subject to record retention requirements currently remain at the premises. There's also probable cause to believe that evidence of obstruction will be found at the premises. And that last line is key. Evidence of obstruction. I think it's the most important thing to look for here, because it's the degree of the obstruction that I think will ultimately determine whether Donald Trump is going to be charged. An outcome that many at this point seem to believe is obvious. And that seems to include Bradley Moss, the well-respected, well-known national security lawyer. He was in one of the clips I played at the top of the show, and he's written an article for the Daily Beast entitled, "It's Over. Trump Will Be Indicted." Bradley, good to see you. Thanks for coming on the program. Appreciate it. All right, so what am I getting wrong here?
You're not necessarily getting anything wrong. So let's, break down a couple parts here. As I noted in the op-ed, it never had to be this way for Donald Trump. When they got the documents, when the National Archives recovered those first 15 boxes in January and eventually got turned over to the FBI in May after some legal haggling, that could have been the end of it if that had been all of the documents. If Donald Trump had ensured everything was turned over back in January, all the records were provided, it would have been no harm, no foul. The archives would have sent it to Justice, and Justice would have said, we're not bothering with this. The reason I believe he is truly in trouble here, and that's what I'm able to infer just from the redacted portions of the affidavit, is that they had to go back twice to get everything. They had to go back in June with a subpoena. They told them everything that's left needs to be properly secured in this storage room. And then they go back with the search warrant, and the search warrant says, as you noted, we believe there's going to be evidence of obstruction. That evidence is they found classified documents in other areas of Mar-a-Lago. They found it in his personal office, in the closet, in his room. That's not where it was supposed to be. That's why he's in trouble.
Right, but let's agree that it's not where it was supposed to be. No doubt he should have returned this. No doubt this is a real problem. But your piece suggests it's done, meaning he's going to get indicted now. And it does seem to me that there are still a lot of open questions about exactly why he didn't turn it over that would determine whether he's going to get indicted. And it seems instead you've already decided, you know, it's going to happen.
Yeah, I mean, and let's be clear. As you indicated at the intro, I know as much as every other pundit out there knows. This is simply my professional opinion. But here's why I believe this will happen. They have now both the facts and the law on their side. They've got the facts that he had the unauthorized documents in an authorized location and that he didn't turn it over when he was supposed to do so. That's enough. It was enough during the Bush administration to put a guy named Kenneth Ford in jail. It was enough during the Trump administration to put a guy named Harold Martin in jail. They were both prosecuted on that same provision. The issue of what his motivations were, it's a relevant consideration. It's not dispositive from a legal matter.
But it does seem to me that when people say, well, if it was somebody else, it is different when it's the former president of the United States. We do allow presidents more access. We do allow presidents to, quote unquote, declassify. And without getting into that issue, my point is just a broader one, which is a former president, someone who was president when he moved the items, et cetera, has a lot more discretion. There's a lot more leeway that we give. No?
There's more leeway and more discretion built in with respect to what we would think of as as personal records under the Presidential Records Act. There's not a lot of discretion built in when it comes to properly marked classified documents. And let's be clear, as you noted, so long as Donald Trump was president, he had unfettered discretion. He could do just about anything he wanted with those records. He could classify, declassify, transmit however he wanted. The moment Joe Biden took the oath of office, Donald Trump became a private citizen with zero authorized access to any of it.
But it does seem to me you're saying that you think he should be indicted. And I guess I'm trying to separate out he should be indicted from he will be indicted, because I think that the Attorney General is going to take into consideration a lot of additional factors beyond just the technical words of the statute.
Correct. No, and you're absolutely correct here. The reason why I'm going across that line is if this was just about collecting records, if this was just about ensuring no more no more classified records were sitting around there, they never had to go with a search warrant. They never had to go to a judge. They could have just kept negotiating with him, kept doing it with subpoenas, kept it under the radar. What makes me think this is going further is the fact that they took that step, what they knew was going to be politically sensitive and explosive, to get the search warrant, to raid Mar-a-Lago. They've provided all this information that reflects not just Espionage Act issues, but the obstruction angle. That's something they can't countenance. They can't permit that to go forward. That's my professional opinion. Well, I would be shocked, and I'll eat crow if I'm wrong.
Well, look, and I'm not saying I know, right? I said at the beginning, I think there's a 40% chance, right? I don't know what the number is. I'm kind of making that up. But your headline was, it's over, Trump will be indicted. Let me bring in Michael Moore, former U.S. Attorney for the Middle District of Georgia. He's long been a skeptic that any indictment is imminent. Michael, good to see you again. All right, so we haven't spoken again since you saw the redacted version of the search warrant affidavit. After reading that, where do you think things stand on this question of whether the former president will be indicted?
Well, I'm glad to be with both of you. I'm still not sold that we're going to see an indictment. You can indict pretty much anybody. Trying to prove them guilty of something is another thing. And because as a former president of the United States, I think you're going to see great caution taken when it comes to a decision about indicting on something like this. Just for curiosity's sake, I looked back before the show and I found a Newsweek article from 2019. It talked about how Trump was going to be indicted during the Russia investigation. Well, it's 2022 and we hadn't seen anything yet. So I think people kind of get the cart ahead of the horse a little bit on this thing. There's a key piece that to me is something that the Attorney General is going to really need to focus on here, and that is this question of a letter that, by all accounts, was sent. I have not read the letter, but it's reported that it was sent to Trump in June, Trump and his team, saying, look, put another lock on the storeroom door, and we'll get back to you about these other documents. That's a pretty strong piece of evidence. If somebody's going to turn around and then say, you had them in an unsecured location, you were keeping things you weren't entitled to, and this type of thing, when they've told you to lock it up, and then if they had to break that lock off, in fact, that they instruct you to put on to get in. These are the kind of little things that I think are going to play in, and not to be too Machiavellian about it, but if you're going to take a swing at the king, you better knock him off the horse.
Well,
and I'm afraid that's a consideration that's going to come into play, especially as we're hearing, sort of the war chants going on amongst some in the Republican Party now about problems we could see. So I think all of this will be considered. Yeah. This is not a black or white issue, something we don't know all the facts on yet. But I think if we just step back and let it play out a little bit, we may see some hesitation move forward.
Bradley, you want a quick response on that?
Yeah, the one thing I'll say, Michael brought up some good points. The letter of what was sent in June didn't say put a lock. It said you are in unauthorized retention of these records. Secure the storage room, everything where it is. We'll follow up with you. Do not touch anything more. And sure enough, with that search warrant, they found things had been moved elsewhere.
And that's going to be a critical question. Go ahead, Michael. I can see you're chomping at the bit to get in one more word there. Go ahead. Yeah.
Well, they said put a lock on the door and we'll be in touch with you. And if I was defending Trump, that's what I'd be telling the jury about every other sentence out of my mouth. They said put a lock on the door, we'll be in touch with you. He put a lock on the door. You know how they got in touch with him? They came out in a search warrant and raided his home. And that's going to be the argument. And so there's going to have to be some serious consideration about what you do if you're the Attorney General when it comes to charging a former president for something like this, for basically keeping some documents. If these things were so sensitive and we're worried about the identification of spies around the world and secrets to nuclear codes and all this kind of thing, I would think that somebody would have come in much earlier.
And I would have thought that there would be charges earlier. That was my point at the outset. Would have been they had these 184 documents earlier, and this comes back to the question of why the obstruction becomes more important than the actual having of the documents. All right, let me ask you both, because last week Trump's legal team asked for what's called a special master to be appointed to review the seized documents to determine if any of the material would be privileged, meaning material the government shouldn't be able to use. In a new filing today, DOJ said it has already gone through all the documents. The FBI has an internal system of identifying privileged information that shouldn't be used, and they say they've identified that material and isolated it. The main issue is that Trump's legal team waited nearly 2 weeks after the FBI search of Mar-a-Lago to request a special master, which typically you would ask for immediately. And U.S. District Judge Aileen Cannon had to have Trump's legal team amend the request because the first version was really more of a political document than a legal one and didn't have some of the basic legal information the court needed. But the judge pronouncing this weekend, before the government even had a chance to respond, that she would likely grant the request for a special master. So where does that leave us now, Bradley Moss?
Yeah, so it'll be interesting to see with this DOJ filing, the subsequent one we're going to get tomorrow, which they're going to get up to 40 pages to explain the situation. It sounds like the whole thing is moot at this point. They already completed the review. The filter team already went through the stuff in Trump's office. The stuff they found that was potentially attorney-client privileged is going to be submitted to the magistrate. The magistrate judge is the one who normally would make this decision on if it is in fact privileged information and should be returned back to him. The rest of their argument, and I had to take a couple Advil every time I read their motions, was somehow executive privilege would come into play and that could prevent the documents from going to the FBI. I don't understand how that would work, how executive privilege from a former president could prevent the FBI, part of the executive branch, from having access to them.
Yeah, Michael J. Moore, that sounds like it makes sense to me. What do you make of it?
No, I think that's right. I mean, the only thing wrong with making the motion for the special master was that they made it too late.
Yeah.
They should have made it immediately upon the seizure of the documents. But there is a distinction to be made about whether or not the FBI team should be able to look at the information and decide what evidence they think it may be privileged. I mean, I assume the FBI would not trust the Trump team to look at information and decide which documents they should give back. So the Trump team's not going to trust the FBI to decide what is and isn't privileged. So this idea of a special master is somebody who either has an appropriate security clearance to go through the documents, to look for attorney-client privileged information. There's nothing unusual at all about that. It happens in cases all the time. This is a process that's been set up. Again, the problem for the Trump team is that they were just late to the party. And they should have filed their motion early on. I expect the judge will probably do it. I think that, if any delay probably inures to the benefit of the former president at this time. But it's an easy request and something that I think, there would be no claim that she abused her discretion in some way by not allowing a special master to be appointed, especially now that we already know at least that the FBI has identified some information that even they think may be protected by a privilege. So it's it's sort of a safety valve, belt and suspenders, I guess, as they move through the case.
Shocking. We've had a civil and nonpartisan but spirited discussion and debate over this topic. Look at that. We didn't have to resort to the outrage machine to have a discussion about something serious like this. Bradley Moss and Michael J. Moore, thank you. Appreciate it. Thank you for watching. Go to newsnationnow.com to find News Nation on your cable provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.